The next case is State v. Shepherd. Each party will have 15 minutes to present their argument. The appellant may reserve 5 minutes for rebuttal. Counsel, how long would you like to reserve?
5 minutes.
Very good, I'll note that, and I will be keeping track of that time. As you know, the clock's up there to your left. As you're looking at it, I will probably not use the bottom clock for rebuttal time. I don't know if you use the top clock the whole time. So if you're looking over there, that's the time you have. When you get to 5 minutes, you'll be into your rebuttal time. I'll try to give you a warning about 1 minute before that starts, so you have an idea that your rebuttal time is coming up at the end of your time.
Thank you.
The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, stay there behind the podium so that we can both visually and audio record you well. If you have any victims or children, anyone in this case, please do not use the name of the victim. Please use initials or some designation like victim or child if you would. With that, the court read your briefs and ready to proceed whenever you are.
Thank you. Good morning, Your Honors. Michael Callahan on behalf of Laura Shepherd. June 15th this year will mark 810 years since a gathering occurred in a little meadow in Runnymede, England. What resulted from that was a document that we now call the Magna Carta. The Magna Carta is the basis and the foundation for what we have today in this country, our laws and our system of justice. One of the most fundamental rights that we hold dear is the right to a trial by jury and a right to a jury of our peers. And I submit to you, Your Honors, that's what's at stake today. This right is protected all through our system, our criminal justice system. It is why there is such an in-depth soliloquy between the court, the trial court, and the defendant and defendant's counsel at the time of the withdrawal of a plea and the entering of a guilty plea. It is why so much time is spent discussing the rights that are given up by entering that plea by the trial court. I will tell these, Your Honorable Justices, that I've been through hundreds, if not thousands, of those pleas conducted by many different judges, conducted them myself, and I know that we in our system often take for granted the importance of those rights. We discuss them with our clients, we discuss them with the defendants that stand before us, and yet we're never actually certain that they understand, even if they may say they do, because they're not us. That's why in this system of justice, our laws and our case law says that when a client or a defendant decides they want to withdraw their plea, that withdrawal shall be freely and liberally granted. In this case, it was not. I submit to the court that motions were timely filed. The motion to withdraw was filed well in advance of sentencing by my predecessor counsel. Throughout the course of the numerous in-court hearings as well as affidavits that were filed, the record was protected. My client had an opportunity to speak both personally at the time of sentencing and through affidavits that we provided to court. And I submit to the court that there is nothing in the rules or the case law that limits a defendant's right to continually assert throughout the pendency of the case their right to withdraw their plea right up to and including the time of sentencing.
But even see in Barnes' case, it kind of set the high water mark and have the quotation you have that these should be freely and liberally granted, indicate the defendant has to have a reasonable and legitimate basis for withdrawing the plea. It doesn't say it's an automatic right the court must grant without hearing or considering anything else. What is a reasonable and legitimate basis? In this case, your client had to withdraw her plea.
So I believe there are numerous. She asserted, and I know the case law is not in support of this, that her previous counsel did not go over the discovery with her. She asserted that she was not given the opportunity to view the body cam footage, for example. But more importantly, she was in the process of mental health counseling throughout the process. Not ordered by the court, this is something she had undertaken on her own. And during that time, certainly after I began my representation of her, she came to me and said, look, I've had these mental health visions, etc., repressed memories that came back, and basically told me that it was going to be a self-defense / battered woman syndrome defense. And we asserted those at various times throughout the process.
Before the plea or just after?
Pardon me?
Before the plea, was she asserting a battered woman defense, or just after the plea when she said, I'd like to withdraw my plea, now I've discovered a battered woman defense?
After. It was never asserted. I was not her attorney at the time of the plea. And none of this was asserted prior to the plea. It was asserted after the plea, prior to sentencing. Additionally, the state filed a response that talked about, in their motion in opposition, that it appears the trial court adopted, at least in part, in its decision, that the state would be somehow prejudiced. However, the state listed no way whatsoever, didn't cite any way that it would be prejudiced, other than its own self-serving statement. And while it doesn't appear that there is a requirement to cite a way that it would be prejudiced, I think more than just saying I'm going to be prejudiced would be necessary to convince the trial court that there is some prejudice that would be assigned to the state. At any rate, Ms. Shepard asserted the potential defenses, and she asserted numerous times, again, up to and including the day of sentencing, that these will be my defenses.
Now, I understand that, if I recall from the record, that your client never testified for the motion for new trial. That the new defense, the new discovered evidence came from your statements and perhaps affidavits at most. Is that fair to say?
Yes. The state and the trial court termed it the hearing on the motion for a new trial. For those here that are familiar with at least what we refer to as a criminal call day, that was held there in a courtroom full of people, a courtroom full of lawyers, and it was my belief that Ms. Shepard was going to, if I may use the vernacular, throw her previous counsel under the bus in a courtroom full of his peers. I did not think that that was an appropriate place to do that, and I asked her not to speak, and she did not speak.
At that hearing, did you explain this is what the newly discovered evidence was and explain your argument?
Yes, that was the hearing.
And was an affidavit ever submitted with what her position was?
That affidavit was subsequently submitted, I want to say April 9th, but I'm not certain of the date, but it's attached to everything, yes. And it set forth the things that you asked me about previously, just a few moments ago. Not only the lack of preparation and discovery by her previous counsel, but the new evidence or the new belief of the assertion of self-defense in battered women's shelter, or battered women's syndrome.
About 1:45 left.
All right, well then, I'd like to save a little bit of time then for when I'm done. So I believe that Ms. Shepard has complied with the requirements set forth. I believe the trial court overstepped their bounds, did not give her the opportunity to exercise her right to a trial by jury. I'm going to ask the court to reverse and remand this back so that she may have that right. Thank you.
Thank you. You'll have your 4 or 5 minutes for rebuttal.
please the court, my name is Stephanie Zeranek, and I'm from the Medina County Prosecutor's Office, representing the appellee of the state of Ohio. The trial court did not abuse its discretion by denying Shepard's motion to withdraw her no contest plea. The plea met all three of the prongs set out by this court in State v. Bursmark. She was represented by competent counsel, she was given a full hearing before entering the plea, and she was given a hearing on the motion to withdraw the plea, during which the trial court considered her arguments. In Ohio, properly licensed attorneys are presumed to be competent counsel.
The fact that you're referring to seem to be kind of the Peter sign, however you say it, those kind of factors and those considerations the trial court looked at?
Those factors are important, Your Honor. They haven't been expressly adopted by this court, but the court has also considered factors in State v. Leland that were similar to the Peter sign factors.
And in State v. Barnes, a recent 22 Supreme Court case, it talked about a motion to withdraw a guilty plea when there was newly discovered evidence. The court in State v. Barnes seemed to say we're not supposed to use those tests when there's newly discovered evidence. Those tests don't apply. So
Yes,
you
sir.
argue those tests still apply despite what Barnes said?
I believe in this case they still do apply. The Supreme Court hasn't stated exactly what it would prefer that courts use instead. It merely stated that they didn't think that the Peter sign or the HISA factors applied. And they did note that this court was one of the courts that did not use the Peter sign or the HISA factors, that we used a different test, which I believe was the Bursmark test.
Why would that test apply to newly discovered evidence when the Peter sign and other tests don't apply? What would make our test different?
I think this test is covered by the same sort of concerns that the Barnes court had when it was considering the withdrawal of the plea. There was concerns about competent counsel, there was concerns about newly discovered evidence being withheld. In this case, counsel did not withhold any evidence from Shepard, and although she alleges that she did not get enough time to review the discovery with her previous counsel, she did not state that at the time of her change of plea. She stated that she was satisfied with her counsel's representation of her, that counsel had answered all of her questions, and that she did not need additional time to meet with counsel. In addition, her counsel discussed the case several times with the assistant prosecutor, and she received a much lighter sentence than the maximum penalty. The 7th District held in State v. Kramer that it was correct not to allow the withdrawal of a guilty plea when the defendant obtained new counsel that disagreed with pleading guilty after the plea. The new counsel, like in this case, thought that the defendant had a viable defense of self-defense. But the 7th District found that recommending a guilty plea was a trial tactic, and just because new counsel thought that there should have been a different tactic was not enough to withdraw that plea.
Were they alleging newly discovered evidence in that case?
I don't believe they were, Your Honor. I believe it was just a question of sort of a change of heart, if you will.
Did the trial court in this case make a specific finding about whether the court believed there was newly discovered evidence?
The trial court stated that they believed that this was just a change of heart rather than newly discovered evidence. Yes, Your Honor. This court has also held in State v. Donner that a defendant could not withdraw her guilty plea to attempted murder of her husband on the grounds that previous counsel did not think that battered woman syndrome would be a viable defense, but her new counsel did.
Counsel, is the viability of the proffered defense a consideration on a motion to withdraw a plea? I mean, is the court to consider whether or not what she's alleging would be her defense at trial? If she's allowed to withdraw her plea, a factor to consider and whether or not she should be able to withdraw her plea?
I think it is, Your Honor, just because there's no point in going to trial if there's already been a guilty plea and there's no viable defense.
How does the court make that determination, the viability?
I believe that they would use factors such as the affidavit that counsel referred to, medical reports, any sort of information such as that. Obviously, we don't have the medical reports in the record, but they could certainly provide some insight as to whether or not there was a viable defense.
And could you tell me what's in the record regarding prejudice to the state for the allowance of the plea withdrawal?
There's nothing directly in the record regarding prejudice to the state, but I believe it's just a case of the usual where the state would be, have to do preparation for trial, they would have to call witnesses, and all of that would of course result in extra burden on the state. In State v. Donner, this court stated that the defendant could have presented expert testimony on battered woman syndrome at the hearing to withdraw her plea. They also stated that being a battered woman does not equal suffering from battered women syndrome. She could have testified that she believed she was in imminent danger of death or great bodily harm, and that the use of such force was her only means of escape. The defendant in that case did neither, and Shepard too did not testify at the hearing to withdraw her plea, or present any expert evidence on battered woman syndrome, or any witnesses. She was given a full hearing under Criminal Rule 11 before she entered her plea. The trial court discussed the maximum penalties, post-release control, community control sanctions, and rights that she would waive with her plea. Shepard stated that she understood everything that the trial court explained to her. The trial court accepted her no contest plea and determined that she had entered it knowingly, voluntarily, and intelligently. She was also given a full hearing on the motion to withdraw her plea. Both her counsel and the assistant prosecutor spoke at the hearing. Her counsel stated that she did not understand battered woman syndrome when entering her plea, but again, as mentioned in Donner, being a battered woman does not necessarily equal suffering from battered woman syndrome. The assistant prosecutor noted that Shepard had had competent counsel and made a knowing and voluntary decision. And the trial court noted that this court has constantly stated that a change of heart does not justify withdrawing a guilty plea. There were also the other
What does that
factors.
mean? Every time someone is changing their plea, there is a change of heart, right? Everyone's decided, I want to do something different. It's always a change of heart. When would something be not a mere change of heart when someone's trying to withdraw their plea? What would be that different standard? It's the opposite of a change of heart. What's the difference that it becomes you can't withdraw?
I believe in reference to this case, Your Honor, it would be a question of that newly discovered evidence. If there was sufficient evidence to show that it wasn't just a change of heart, that there was sincerely a different,
That doesn't sound like a change of heart. That sounds like someone who discovered new evidence and had a reason for wanting to withdraw their plea, which the court should examine beyond just saying, well, that's a change of heart, too bad.
yes, Your Honor, I agree with
Did
that.
the court properly consider whether or not there was newly discovered evidence in this case and weigh that?
The court did consider whether there was newly discovered evidence and found that there wasn't. Basically, that there was a simple change of heart in this case. The
What
court,
was the nature of the newly discovered evidence that the court led to believe was not sufficient to be the basis for withdrawal?
I'm not sure, Your Honor, like I said, the medical reports are not in the record. The only thing that we have is the affidavit of Ms. Shepard herself stating that she believed that there was newly discovered evidence and that there was, that she suffered from battered woman syndrome.
When you say you're not certain, is the court's order such that you can't tell why the court made a decision that it wasn't newly discovered evidence?
Yes, Your Honor, I don't think it's completely clear why the court decided what it decided. It did list the factors from State versus Whelan. It did not get into details about the medical reports or anything else that it had considered in regards to the withdrawal of the plea.
Isn't that somewhat problematic for us if the court didn't adequately explain its decision?
I don't believe it is, Your Honor, just because of the fact that there was a decision by the trial court that the trial court did indeed determine, looking at the evidence that we don't have, that there was no newly discovered evidence and no basis for withdrawing the plea. The trial court also considered the other factors that this court discussed in State versus Leland. The trial court fully and fairly considered the motion and the arguments of counsel. The court did say that the timing of the motion was reasonable, although the grounds for it were not. And they stated that Shepard understood the charges and the maximum penalties. The trial court noted that, quote, even though the defendant states in her motion that she believes additional information discovered provides a potential basis for a defense, nothing has changed since the time of the change of plea except for the fact that the defendant simply changed her mind. And I would say that that would be part of what we were referring to earlier, that the trial court had that information before it and still determined that there was no basis for withdrawing the plea. And as we talked about earlier, we talked about State versus Barnes. In this case is more similar to State versus Colvin out of the 8th District, where there was no new evidence, but the defendant had had a different perspective on his plea, and that was why he chose to move to withdraw the plea. And the motion to withdraw that plea was denied, and the 8th District affirmed that denial, saying that there was no reason for the defendant to withdraw that plea, that the mere change of heart was not enough.
Counsel, was there evidence of a diagnosis of battered women syndrome?
I don't believe there was, Your Honor, and that's why I'm making the delineation that being a battered woman does not necessarily equal having battered woman syndrome.
But it doesn't necessarily mean you don't.
No, it does not, you're correct. But like I said, the only information that we have comes out of the trial court reviewing those statements in the medical records and in Ms. Shepard's affidavit, and determining that there wasn't enough newly discovered evidence to withdraw the plea. The Supreme Court of Ohio wrote in State v. Z that when considering the trial court's denial of a motion to withdraw a plea, quote, we defer to the judgment of the trial court because the good faith, credibility, and weight of the movement's assertions in support of the motion are matters to be resolved by that court. If there are no further questions.
I have a quick question. So the trial court's entry says that for some factors and the lack of any testimony presented at the hearing to withdraw the plea. Can the court use the defendant's failure to testify at the plea hearing as a reason to deny a motion to withdraw a plea?
I don't believe so, Your Honor. I think that that would be, violating various rights, but that was a consideration that she didn't present any expert evidence.
Okay, and then there's a at the beginning of the trial court's entry, the trial court says there was no evidence of any kind given to the court to allow the court to allow her to withdraw her plea.
I know that there was some sort of folder presented to the court
At that hearing?
at the hearing before sentencing.
Okay.
So I'm not entirely sure where that would have come from.
Thank you.
Therefore, the state of Ohio would respectfully ask this court to affirm the judgment of the trial court. Thank you.
Thank you. As you're coming up, Mr. Callahan, you have your full 5 minutes, so your time will be that bottom clock if you're looking over there for time.
Thank you, Your Honor. I don't suspect I will take it unless the court has questions. The state has cited in its briefing today numerous cases that it wants this court to rely upon. Zia from 1992, Donner from 1994, Adams from 1980, and this court's own case, Whelan, from 2007. It glosses over the fact that the Barnes case was decided by the Supreme Court as recently as 2022. And that is what is controlling, and I would submit to you, that is what is controlling of what we're here about today. And the similarities between the Barnes case and the Shepherd case are just striking. To the point where even Barnes didn't withdraw his plea and attempt to withdraw his plea until the eve of sentencing, I believe the day before, and yet we did it months before. He wanted to assert a self-defense defense, basically the same as Ms. Shepherd. He was initially denied, and the Supreme Court said, no, he should have been given that opportunity. As to prejudice of the state, I'm guessing 810 years ago, King John thought there was some prejudice going on in that field as well, but still signed off to give the barons, which eventually gave us our rights to trial and trial by jury and a jury of our peers. I'm going to end with, and I hope the court will bear with me, it'll only take a moment, the opening words from Barnes in the decision, because I think therein lies the crux of everything we're here about today. We begin by repeating what this court established 3 decades ago in Zia. A defendant's pre-sentence motion to withdraw his plea should be freely and liberally granted. The standard makes clear that when a defendant pleads guilty to one or more crimes and later wants to withdraw that plea before he has been sentenced, the court should permit him to withdraw his plea. This is the presumption from which all other considerations must start. Those are not my words. Those are the words of the Supreme Court in Barnes, the 2022 case that we are citing today. I submit to you, Laura Shepherd never got that presumption. The trial court appears to have gone out of its way to deny the motion rather than give her the presumption that is provided for in Barnes. Therefore, I'm going to ask this court to reverse the trial court's decision, remand this back so that Ms. Shepherd can exercise her constitutional right to a trial by jury. Thank you.
Thank you. The court will take the matter under advisement and issue a decision in due course. The clerk of the court will mail a copy of the decision to you on the date of release. The opinions are also posted on the High Supreme Court website. With that, I'd like to thank both attorneys